So the ATF is now trying to avoid being sued by JSD Supply by rescinding the cease and desist letter that they served, which shut down the sale of 80%ers and parts on their website. So let's talk about this. But real quick before we jump into this video, if you think the ATF needs to be abolished, go ahead and hit that like button and subscribe. Also want to mention once again that channel merch will be releasing really soon. I know a lot of you guys have been asking for channel merch for a long time, and I just haven't been able to do it myself. And I finally partnered with Bunker Branding, which is owned by Matt from Demolition Ranch. Awesome company, awesome guy. So they're running our merch. It's going to release, I'm hoping, about mid next week. I will give you guys the official link when it releases, and they're only about like $25 a shirt. So again, not super expensive, fast, quality, and I'm really happy with all the designs. But again, once that goes live, once that link is official, I will let you all know. So I guess in the intro, about a week ago, the ATF attempted to shut down JSD Supply for selling 80%ers and other parts on their website. The ATF served JSD Supply a cease and desist letter, and as a result, JSD Supply temporarily shut down their website. One critical thing that came out of this and the cease and desist letter is the fact that the ATF is now in the position that a company who sells 80%ers and other parts like triggers, springs, barrels, all of those things on their website without an FFL is violating the GCA. The ATF claimed that if a company sells 80%ers and various parts on the same website, that is a violation, and it doesn't matter if the company sells the items during a single transaction or multiple transactions. They're saying it doesn't matter at all. The ATF claims that if a company simply has all these items available for sale on their website, then it is a violation as defined in the GCA. Now, the cease and desist letter came on the heels of the ATF releasing their final rule on frames and receivers about a month ago. Under the new rule, gun stores and FFL holders will now have to serialize 80%er kits that they have in their inventory. On top of that, they will also have to run background checks on individuals who attempt to purchase those items. Now, that new rule is not supposed to go into effect until mid-August, but the ATF decided to jump the gun, and they are trying to enforce a variation of that rule against JSD Supply and other companies. In response to receiving the cease and desist letter, JSD Supply temporarily shut down their website, and they filed a lawsuit against the ATF. In their complaint against the ATF, they also sought a temporary restraining order, or a TRO, against the ATF, and they sought a motion for preliminary injunction. In their complaint, JSD Supply stated that defendants, their vague cease and desist order, without any statutory authority, has forced the plaintiffs to immediately suspend all retail sales of its entire product line, causing immediate and substantial financial losses, violating the Fifth Amendment, and infringing on the Second Amendment rights of plaintiff and its customers. They also argue in the complaint that the ATF has specifically and repeatedly explained that firearms parts such as barrels, triggers, springs, etc. are not firearms under federal statutory law, including the GCA, and thus are entirely unregulated by the ATF and unable to be regulated by the ATF absent an additional grant of statutory authority. Even more so, the ATF has specifically and repeatedly determined that the 80% frames and receivers which plaintiff sells are not firearms under the GCA and thus are entirely unregulated by the ATF. So the complaint by JSD Supply can be boiled down to a very basic and factual argument. There is a plethora of ATF determinations that parts are not firearms and therefore are not regulated under the GCA. Also, there are various determinations by the ATF that 80%ers are not firearms and therefore not regulated by the GCA or the ATF. However, the ATF has once again decided that they want to change their policies and practices, change their rules, and now try to apply this new rule without really any notice or anything. In conjunction with their complaint, JSD Supply also filed a motion for an emergency TRO and for a preliminary injunction. A TRO is an order by the court immediately prohibiting a threatened action, but is only a placeholder until a preliminary injunction hearing can take place. In contrast to a TRO, a preliminary injunction is an order which prohibits an action by the ATF in this case and preserves the status quo while the actual court case is going. So a preliminary injunction is a little bit more permanent. It goes for the entirety of the lawsuit, while a TRO is more of a temporary stopgap. In reaction to those motions, the district court did deny the TRO, but they did grant a hearing for preliminary injunction. Well, in response to that in this lawsuit, all of a sudden the ATF decided that they wanted to take back what they just did. And they just sent a letter to JSD Supply rescinding their cease and desist order, and this is an attempt to moot this lawsuit. In the new letter by the ATF, it states, "Dear Mr. Olson, the cease and desist letter dated May 9th, 2022, and issued to your client JSD Supply is hereby rescinded. Please be aware that the ATF's longstanding position that firearms kits that are designed to or may readily be converted to expel a projectile by the action of an explosion are firearms as defined by the GCA, and that remains in effect. Any questions about whether any particular product or products would be considered a firearm for purposes of the GCA and its implementing regulations may be submitted to the ATF for classification. So essentially, the ATF is trying to rescind their cease and desist letter, but at the same time, they're saying that they're still considering those actions to be illegal. In response to this recent letter from the ATF, JSD Supply filed a reply to the court. In that reply to the court, they stated on Friday, May 20th, 2022, 3 hours after this court issued its order setting a briefing schedule and hearing on plaintiff's motion, ATF seems to have experienced a crisis of confidence. The agency emailed a letter to plaintiff's counsel in an apparent effort to moot the case and hereby prevent a ruling from the court. Without any explanation, the first sentence of that letter states that the cease and desist letter dated May 9th, 2022 and issued to your client, JSD Supply, is hereby rescinded. However, the second paragraph of the ATF letter undercuts that claimed withdrawal, asserting the basis for the agency's prior letter. In other words, what the agency seemingly gives in its one-sentence recession, it takes back in the next paragraph. What is more, after filing of this matter, it was learned that ATF has served another cease and desist order on another retailer of unregulated gun parts and 80% of frames and receivers in Missouri. ATF's letter to KM Tactical advances identical positions using identical language and makes identical threats as ATF's purportedly rescinded cease and desist order to plaintiff. Thus, ATF continues to press its new and flawed policy on 80% of frames and receivers and firearms parts. Defendants cannot credibly claim that the threat to plaintiff is over when every indication is that the ATF is moving ahead with the premature enforcement of its new policy. So essentially, the ATF is trying to moot the lawsuit against them, but there is no guarantee that after the case may be thrown out by the court, that the ATF won't just go back and try to enforce this rule once again. Also, JSD Supply argues that the case is not mooted by the rescinding of the cease and desist letter, since there are still challenges in their lawsuit against the policy in general, and they are also challenging that new rule on frames receivers, which goes into effect in August. So you can see the tyrannical game that the ATF is playing in this case. They're going after companies, threatening actions against them, shutting them down, and then when they get sued for engaging in this unconstitutional conduct, they are then rescinding the letter, rescinding their actions, and saying, no, court, just throw this case out. We're not going to do it anymore, without any guarantees that they won't try to go after these companies once the court throws the cases out. So this is really going to be interesting. If the judge was already on the fence with this ATF action, the judge might be really, really angry at this tactic that the ATF has engaged in, and they might not decide to moot this case. They might actually grant a preliminary injunction against the ATF if they think that the ATF is playing this weird game and they're really actually threatening these companies. So as we get more information, I will let you all know. If you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algore's rhythm. It adds fuel to his jet, and it signals to YouTube that you guys see value in these videos in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And don't forget, this is Built by Armed Scholars, and this nation will be maintained by Armed Scholars.